All right, good people. Here we are once again, and we're going to deal with Wisconsin versus Yoder. What's called compulsory attendance. This has everything to do with schooling, ironically. School attendance, ironically, right? Amidst the situation with the COVID-19 virus, which we're going through now, this is a little bit different concept and perspective. It deals with religion, it deals with education, and it deals with the rights, the 14th Amendment right of each and every single individual within the Amish community. So let's talk about the Amish exception, Wisconsin versus Yoder in 1972. Now, the Amish, I call it the Amish paradise for a particular reason. And the reason why I call it this is because their customs and their traditions are very different from the customs and traditions of the individuals and religions in which we all know, right? Catholicism, Baptists, Methodists, Presbyterians, um, individuals within non-denominational churches and backgrounds. The Amish are a little different. Here's what I mean by this, right? So the original case came from Wisconsin, the Greene County, Wisconsin, and it deals directly with compulsory attendance, right? And basically, what that means is schools mandate students to be in school at a specific age, right? After they reach an age range, or possibly even grade level, um, they are no longer required to attend public schooling, right? And within Wisconsin, compulsory attendance basically doesn't stop at the eighth grade, right? You have to continue on throughout high school or the perspective of 18 years of age, which leads into the Amish situation, right? So the Amish believe that the laws which were set forth in the state of Wisconsin violated their First and 14th Amendment to the Constitution because after the eighth grade, the environment is in the opposition of faith. In other words, in the Amish religion, in Amish faith, if you are Amish after the eighth grade, you are pulled from school and now going to be one, homeschooled, and two, work within the family. Um, the background of Amish are interesting. One, there is no significant contact with the world. And what I mean by that is no television, no internet, right? They are basically cut away um, from society to a certain extent, and they're able to come into society, of course, but their dependence upon what we depend on a regular and daily basis doesn't exist, right? So the conclusion was that the county fines defendants $5 each, and not only that, tells them to go to school. Now you might be asking yourself, wait a minute, $5? That's it? Keep in mind it's 1972. Number one. Number two, the economy is a little bit different overall, and three, the perspective of punishment are viewed differently in the north or Midwest, however you want to look at it, as opposed to how we view punishment and perspective in the South. So the Amish community, um, in particular, Mr. Yoder, sues the state of Wisconsin for violating their First Amendment right, which is the right of religion, and the 14th Amendment right, which requires the state and all people to treat each other equally, as the law states you should. Now, allow me to restate the 14th Amendment to you, just in case you didn't get it in regards of Gideon versus Wainwright and Tinker versus Des Moines in the cases I posted for you. Is that the 14th Amendment specifically states that all persons born are naturalized in the United States, right? So if you're born here or you receive citizenship within the United States, you are subject to the jurisdiction thereof are citizens of the United States. So therefore, because you are born in the United States or you obtain citizenship in the United States, you specifically are a citizen of the United States and therefore reside within a specific state and a resident of said state, right? You are fully an American. And because you are fully American, no state shall make or enforce any laws, right, which shall abridge the privileges or immunities of citizens of the United States. In other words, no state law shall be created to violate the individual rights of said individual or said people or group of people. Um, and because of that, these rules should not apply. All right, and the state and therefore no state shall deprive any person of life, liberty, or property without due process of law. So the states or the federal government shall not deprive an individual of their life, should not deprive an individual of their individual liberty, and should not deprive that individual of the property without due process of law overall. No matter if we believe the law is against us as individuals or as a group of individuals, the law is there to protect us overall. And keep in mind, nor shall it deny to any person within its jurisdiction the equal protection of law. So therefore, the law must equally protect individuals, no matter your religion, your background, your perspective, or anything of that nature overall. And with that in mind, it's important to understand the next slide that we have here, right? And let's talk about the actual issues that are in play in regards of Yoder, Wisconsin versus Yoder. That Wisconsin, by law, children need to be educated to age 16. Normally, for Wisconsiners, um, by age 16, you're practically a sophomore, possibly a junior, right? And by that time, you must be able to participate effectively and intelligently in our political system. So at this age of 16, Wisconsiners or Wisconsinites, if you will, believe that at age 16 you are able to fully understand and grasp the immense enormity of politics, of law, of individual responsibility, and therefore you be able to be more self-reliant and self-sufficient from starting at the age of 16 as opposed to age 13 or 14 years of age, right? So they believe that the mental mindset of young people are able to be not only self-sufficient and self-reliant and able to be effectively and intelligently understand our political system only at starting at the age of 16, not less. And because of this, the Amish believes overall that by being in eighth grade and completing their eighth grade year, they are sufficient in regarding the perspective of what Wisconsin believes in at age 16. Their young kids in the Amish community, once they finish their eighth grade year, believe they are effective and intelligent enough to understand political systems, but not just that, they're also to be self-reliant and self-sufficient. But more importantly, they're schooled by family and their religious traditions overall. They believe, the Amish that is, that student achievement adequate education in the three R's by eighth grade, right? The reading, the writing, and the arithmetic. I know it doesn't start with R's. That's how it is. You all know this. Don't act like you don't know this, right? The additional 2 years are unnecessary for the Amish kids, right? So they're saying, look, our kids in the Amish community, based upon our religious beliefs and background, truly believe overall that they are able to understand life's intricacies, perspectives, and so on and so forth at the eighth grade. The next 2 years, possibly even 3 years, are just plain unnecessary. And just to put the state's thumb over the people of Wisconsin and don't care specifically about the religious factors that may be behind it. So in lieu of this, formal high school is an environment hostile to their beliefs. So in other words, the Amish truly believes that that high schools itself are damaging and detrimental to the well-being of their young people, their kids. In other words, one, the competitive nature, academically and athletically harms the students mentally, physically, and emotionally. They also believe that they have social pressures about styles that's happening within society, the manners in which you must abide by societal standards, but more importantly, the manners in which your friends may have, in which forces you to choose between what society wants versus what your friends want versus what your family may want. And at the same time, social pressures in a matter of ways, right? How individual children react to situations, but not only react, but also act itself in their ways, right? How they present themselves to the public, to the family, and to their friends themselves. All these concepts itself overall harm the perspective of young people, right? So they're arguing this fact overall and saying this is detrimental to their overall well being in society. This is a key component in what the Amish truly believes and want to believe in, but more importantly, they're trying to push upon the individuals and lawmakers and educational managers within the education field of Wisconsin. This takes children away from the community during formative adolescent years. So they truly believe that because of high school, it takes these children away from forming a relationship with family, building themselves as young adults, no matter if you're female or male, within an ever changing world, but more importantly, within their culture. They're not overly concerned about how society is going to work, but how their world will work overall. Now, this leads us into the perspective of rules, right? So now we're going to get into perspective of rules. And what I mean by the perspective of rules, Wisconsin's compulsory attendance law again starts and ends with at a preschool level all the way to 16 years old. That is their cut dry issue. All right, that's what they believe in. That's the law that's set forth by Wisconsin. Now the Amish again state that these rules that has been manifested and created by the people by the Congress people of Wisconsin and followed by the citizens of Wisconsin are wrong, damaging to them, and more importantly, in violation of their religious freedoms, in violation of the 14th Amendment, as as being protected equally upon under the law itself. Now, quickly, the analysis is pretty simplistic overall, in that Wisconsin argues that you're not going to be self-reliant, right? Become dependent upon the system itself, and the system leads into two ways, right? One is that if the Supreme Court allows Yoder to win, what happens is that it formulates the concept that students will be not only reliant upon their families throughout, but they will not be self-reliant. In other words, they won't be able to think, act, and do what they honestly please and need to be done in order to be productive citizens in society. Remember, the Wisconsin lawyers believe you are not only Amish, but you are residents of Wisconsin. The second concept is that It fosters ignorance, Wisconsin argues, that the concept that you're going to just purposely just subjugate the concept of high school as something that is draconian. That high school is an educational system that's not needed in society, proves how their thought process isn't aligned with the social values of America and Wisconsin. This is their argument that they're making, not me. Their argument, right? And that kids are just being used as child labor on community farms, right? It's important to understand that during this time frame within Wisconsin, young kids at this time frame are working. And what I mean by working, I mean the fact that they are specifically working on farms, learning labor, learning how to provide for families at that young age with their families themselves, not getting full-fledged education background and a wealth of knowledge on a background basis so they're able to do more than just work on a family farm and being subjugated to being alone in a religious factor that's not conducive with what's going to happen either now or in the future of society. You cannot treat their children as child laborers. Is what they're making the point out to be. Now, in regards to the Amish community, their argument is just the same as Wisconsin. It's a three-pronged approach. First, communities have 200 plus years of history, indicating their system of vocation is effective and communities are self reliant. In other words, what they're saying is that throughout history, the people of the Amish community have consistently shown that they have been effective, efficient, for not only from themselves, but also for their own communities themselves. That they don't depend on society or the government, they depend on themselves. And because for over 200 plus years of their dependence, they have learned that they don't need Wisconsin or the United States for handouts and so on and so forth. All right. So, um, so the next approach they have is that they reject public welfare, right? So it's more in line or a continuation with their first argument. They're specifically stating to you overall that that they don't reply or need the public or the federal government or the state government to provide them with money, with food, or so on and so forth, that other individuals need to, because the families within the communities of the Amish depend on each other and therefore are not reliant upon the government itself. But the third concept, or the third prong approach, in which the argument that the Amish community are making, is that an informal vocational education continues for these children. In other words, the children within the Amish community, while working and building the family into a strong and effective unit, are also learning in their homes and in the community. It may not be a formal education within Wisconsin. However, it is an education within the community in which they are from on a religious basis. 1 or 2 years of high school does little to prepare a child for life in an Amish community. Remember, one, they're isolated for a particular time frame. And what I mean by isolated, I mean they don't have the communication like we do. We're dependent on phones and cell phones, at least at that time, on phones and newspapers. They aren't dependent upon that. We are at least now are dependent upon the internet. The students in the Amish community are not dependent upon the internet because they don't have the internet. They don't even have television, computers, anything of that nature. They are relied upon for everyday usage overall, right? So they don't have this perspective. They don't need this because they depend again on each other. Their education extends within the community, not within the educational constraints of the west of Wisconsin. With that in mind, the conclusion is this: is that one, a state's interest in the universal education, however highly we rank it, is not totally free from a balancing process when it impinges on the fundamental rights and interests, such as those specifically protected by the exercise clause of the First Amendment and the traditional interest of parents with the respect to the religious upbringing of their children. This is a better way to explain this, right? A better way to explain this is this way. What the Supreme Court justices are talking about here is simple. They're specifically stating that based upon religious factors, that the individuals who are part of the Amish community has every right to go about educating their children the way they seem fit, right? This prepares them for additional obligations therefore after in regards to the Amish community. But not just that, these same justices stated that education must be assessed in terms of its capacity to prepare the child for life. It is not the concept of preparing their child for life in the world in which they live in, but prepare their child for life in the community in which they will be in and they will be a part of. That is a critical component to this perspective overall. But not just that. They also talk about that when Thomas Jefferson emphasized the need for education as a bulwark of a free people against tyranny, there is nothing to indicate he had in mind compulsory education through any fixed age beyond a basic education. Now, number three is like the most important conclusion of the conclusions you're going to read and see. Okay, so the it was number one. Let's go back a second. This was a unanimous decision in favor of Yoder over Wisconsin. Now, keep in mind, two Supreme Court justices did not participate in this particular hearing. This is Justice Rehnquist and Justice Powell. So the justices, Justice Berger, Douglas, Brennan, Stewart, White, Marshall, and Blackmun. Again, Supreme Court Justices Berger, Douglas, Brennan, Stewart, White, Marshall, and Blackburn are saying this in unison. They agree with the fundamental perspective of what Thomas Jefferson is saying, or said before, that education is the bulwark of free people against tyranny. The more educated someone happens to be, the stronger they are against the concept of tyranny. And this is an important factor to understand because they understand that education is important and that the Amish community aren't stopping education. They're educating their children and their community the way they deem fit for over 200 years, which has worked for them. But number two, the second portion of conclusion number three is as equally, if not more important than this. And they're saying that compulsory education through any fixed age beyond a basic education was not indicated in the mindset, the ideology, or the perspective of Thomas Jefferson. This was not even a thought. This wasn't a perspective in which they believed this was going to be the case, right? They truly believed overall that Thomas Jefferson believed in the concept of education, not how a person would be educated, right? Let me repeat this again. It's not about the concept of the education perspective also. They were concerned about the concept of education perspective, but this education perspective is based and predicated upon the community, upon the religion, and that it should not be compromised. Thomas Jefferson didn't think of the concept, well, if Amish people believe in X, therefore we need to make sure we have laws to ensure X. Or Thomas Jefferson didn't believe that education can literally stop at said age of 16 or 17 or 18. It's the fact that it's predicated not because of age, it's predicated based upon the knowledge they can receive to go against tyranny, but also the perspective that as long as it doesn't violate individual rights. Everything is predicated upon your individual rights. Also, these 7 justices also stated the First and 14th Amendment prevent the state from compelling respondents to cause their children to attend formal high school to age 16. In other words, the 7 justices stated, look, the First Amendment when it comes to religion, the 14th Amendment in regards of equal protection under the law, prevents any state, including Wisconsin, to tell someone or a community that believes in taking their children out of school and being homeschooled, if you will, after the 8th grade. States don't have the right to harm individual liberties as well as individual religious perspective. The states don't have that power, shall never have that power, and will never have that power. The next conclusion states that it cannot be overemphasized, and this is a quote given by the Supreme Court justices. In particular, I want to say Justice Brennan and Stewart wrote this together by saying that it cannot be overemphasized that we are not dealing with a way of life and a mode of education by a group claiming to have recently discovered some progressive or more enlightened process for rearing children for modern life. This is important. They're saying that the Amish people have over 200 years of evidence to prove that their way of life works for them and that they are productive in their community, even if they are secluded from the outside, from the inside world, if you will. So the evidence, the 200 plus years, shows that they're able to be productive citizens without the formal education of the state. But just the same, the 6th point is important. It was incumbent on the state to show with more particularity how its admittedly strong interest in compulsory education would be adversely affected by granting an exception to the Amish. In other words, this was an out for the West for Wisconsin. Here's what I mean that it's an out. The 6th part to their conclusion overall states that if the Amish believes this and their evidence proves this perspective over a 200-year frame, then the Amish must be able to apply for a homeschool license. This is where the homeschool industry, if you will, of education has started to rear its head, right? So because the Amish won their case, they had to form some form of Amish school. that therefore they're able to take their children out of school, out of public education, at the age of 8, and they will be able to be homeschooled under the curriculum and guidelines of a particular state. In this instance, it's Wisconsin. So while they are educated based upon a curriculum, at least at the time, the Wisconsin curriculum, eventually down the road, there have been more and more Amish schools that have been not only accepted, but more importantly, that have been started and has worked over the years, in particular like New York and Wisconsin and other areas of that nature, to formulate their school to educate their children. And that formulation of school doesn't have to abide by the curriculum set forth by the state. It can now be applied to the curriculum created by the Amish community themselves. Okay? So this case is very interesting overall, and allows for higher depth thinking in regards of how education overall is assessed. Also, keep in mind other exceptions, right? The Amish have effectively used a similar argument to obtain, number one, congressionally granted exception to Social Security taxes. In other words, they have an exception to Social Security taxes. In other words, paying or receiving Social Security, but also the exemption from local building codes. In other words, now they're able to create schools with the exception of dealing with building codes granted by the state or by the city. In other words, because they have so much land outside of the society itself, they can create schools and create buildings that fit their narrative without having it to be inspected by the state or by city inspectors. They have that right to do just that. To build the way they wish to build without being taxed, because they are a religious based school now. They don't have to abide by state standards. They can create their standards within the realm of their religious background and basis. All right. Also, with that in mind, we have literally just completed the concept of Wisconsin versus Yoder. All right. Again, keep in mind this was a 7-0 decision. Two of the Supreme Court justices did not participate in this particular court hearing. That was, again, Justice Powell and Justice Rehnquist. And keep in mind that the conclusion was a six-pronged concept for 7-0, right? The free exercise clause of the First Amendment in regards of religion would have been violated by the state of Wisconsin upon the Amish community. That education must be assessed in terms of its capacity to prepare the child for life, even if that preparation deals with a different type of life for the Amish. They also agree, at least the Supreme Court justice tells you, that Thomas Jefferson emphasized education because education will always overturn tyranny. However, that education perspective didn't have in mind that the states will determine how old an individual must be to continue their education or be out of education versus the religious background of individuals. But not just that, it also deals with the violation of the First and 14th Amendment to the Amish community within Wisconsin by the state of Wisconsin, and that it also has an infant. They can that the progressive and more enlightened process for rearing children for modern life isn't dependent upon the school system and the state. It's dependent upon their religious background and the religious perspective of the Amish. And of course, compulsory education by allowing individuals community based upon religious perspective to educate their child the way they deem fit that benefit their community as a whole. All right, and we talk about the analysis and what there was argued in the actual case itself. That Wisconsin again believed that the individuals within the Amish community will be self reliant upon upon Wisconsin. That it fosters the concept of ignorance upon the people in the Amish community, and kids are just treated as child laborers and not as individual students with the opportunity to learn and to be effective in communities and also in society. While the Amish people argued the fact that for over 200 years of history, they have done it this way without any peep from the Amish community to the Wisconsin or to the people of New York or so on and so forth. Even they understand this concept so much they even reject public welfare. They reject the concept of Social Security and even understand that informal vocational school continues in their community and their children still learn valuable concepts within their community overall. All right. All right. This concludes the concept of Wisconsin versus Yoder. Again, be safe, be healthy, and be well. I will also provide additional information on manipulatives, summaries, and so on and so forth as it relates to Wisconsin versus Yoder. Um, we will continue this process. We have a few more cases to go, and I will upload those for you for your learning capacity. All right. Please do not hesitate to email me if you have any questions, comments, or concerns. I'll be more than happy to answer them for you. All right. Look forward to hearing from you all again, and I will talk to you soon.